For our next case, we have the Supreme Court of the state of Arizona, and this case is dealing with the availability of goods and services to people through non-discrimination laws. So the state of Arizona, like many states, has a law that provides that people should have equal access to commercial services, notwithstanding affiliations or relationships or statuses such as homosexual status or gay relationships. And in this particular case, a business wanted to deny this in the context of wedding invitations for gay weddings, and the Supreme Court of Arizona has heard the case and said that there is, in fact, a First Amendment interest that extends to people when it comes to wedding invitations. So the law does not apply to the business in this context because the First Amendment is a superseding interest. So let us read the case and see what it has to say and teach us. The rights of free speech and free exercise, so precious to this nation since its founding, are not limited to soft murmurings behind a door of a person's home or church, or private communications with like-minded family and friends. This guarantee protects the right of every American to express their belief in public, and this includes the right to create and sell words, paintings, and arts that express a person's sincere religious beliefs. With these fundamental principles in mind, today we hold that the city of Phoenix cannot apply its human relations ordinance to force Joanna, Duka, and Breanna Koski, owners of Brush Nib Studios, to create custom wedding invitations celebrating same-sex wedding ceremonies in violations of their sincerely held religious beliefs. Duka, Koski, and Brush Nib have the right to refuse to express such messages under Article 2, Section 6 of the Arizona Constitution, as well as Arizona's Free Exercise of Religion Act. Our holding is limited to plaintiffs' creation of custom wedding invitations that are materially similar to those contained in the record. We do not recognize a blanket exemption from the ordinance for all businesses. Likewise, we do not, on jurisprudential grounds, breach the issue of whether plaintiffs' creation of other wedding products may also be exempt from the ordinances. Duka and Koska's beliefs about same-sex marriage may seem old-fashioned or even offensive to some, but the guarantees of freedom of speech and freedom of religion are not only for those who are deemed sufficiently enlightened, advanced, or progressive. They are for everyone. After all, while our own ideas may be popular today, they may not be tomorrow. Indeed, we can have intellectual individualism and reach cultural diversity only at a price of allowing others to express beliefs that we may find offensive or irrational. The freedom to differ is not limited to things that don't matter much. The test is the substance of the right to differ as to things that touch the heart of the existing order. Given this reality, the government must not be allowed to force persons to express a message contrary to their deepest convictions. Rather, plaintiffs are entitled to continue to advocate the utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths, and own deep aspirations to continue the family structure they have long revered. Although this case is about freedom of speech and religion, it suits the preferred analysis of our dissenting colleagues to reframe it as one that involves discriminatory conduct based on customer sexual orientation. This mischaracterization reflects neither plaintiff's position nor our holding. Literally none of the examples of invidious status-based discrimination the dissent invokes would even be remotely permitted by our holding today. Plaintiffs must, and they do, serve all customers regardless of sexual orientation. However, by focusing solely on anti-discrimination purpose of the ordinance, the dissent engages in a one-sided analysis that effectively deprives plaintiffs of their fundamental rights to express their beliefs. But no law, including a public accommodation law, is immune from the protections of free speech and free exercise. Rather, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by words or act their faith therein. The enduring strength of the First Amendment is that it allows people to speak their minds and express their beliefs without governmental interference. But here the city effectively cuts off plaintiffs' right to express their beliefs about same-sex marriage by telling them what they can and cannot say. And to justify this action, both the city and the primary dissent claim that if we dare to allow plaintiffs to express their beliefs, we in essence run the risk of resurrecting Jim Crow laws of the Old South. But casting plaintiffs' free speech and free exercise rights in such a cynical light does grave harm to society. As Justice Jackson observed in Barnett, struggle to coerce uniformity of sentiment in support of some end thought to be essential for their time and country have been waged by many good as well as by evil men. But inevitably, those bent on its accomplishment must resort to ever-increasing severity. We'd be wise to heed this warning about government efforts to compel uniformity of belief and ideas. As governmental pressure towards unity becomes greater, so strife becomes more bitter as to the unity shall be. Ultimate futility of such attempts to compel coherence is a lesson of every such effort, from the Roman drive to stamp out Christianity as a distributor of its pagan unity, the Inquisition as a means of religious and dynastic unity, the Siberian exiles as a mean to Russian unity, down to the fast-falling efforts of our present totalitarian enemies. Those who begin with coercive elimination of dissent soon find themselves exterminating dissenters. Compulsion unification of opinion achieves only the unanimity of a graveyard. The compelled speech doctrine is grounded on the principle that freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. The compelled speech doctrine was first articulated in a case called Barnett. There, the Supreme Court addressed a state law requiring a child who was a Jehovah's Witness to salute the American flag. For both the child and his parents, saluting the flag violated religious beliefs. The court struck down the law as violating the First Amendment, stating that the government cannot compel any individual to utter what is not in his mind, and that all citizens have an autonomy over beliefs and personal attitudes. There are, generally speaking, two lines of cases addressing compelled speech. The first involves regulations requiring an individual to express a prescribed governmental message. For example, in Woodley, the court held that the law was unconstitutional because it forced a Jehovah's Witness in violation of religious beliefs to display the state motto, "Live free or die," on his license plate. A second line of compelled speech cases involves a governmental regulation that compels a person to host or accommodate another's message. This line of cases includes government regulations compelling a person to engage in self-censorship to avoid hosting another's message, as well as regulations forcing a person to respond to another's speech when they prefer to remain silent. The fundamental principle underlying both lines of compelled speech cases is that an individual has autonomy over his or her speech, and thus must not be forced to speak a message he or her does not wish to say. And Hurley is instructive on point. There, a private group of veterans was granted a permit by the city of Boston to sponsor a parade. However, the council refused to allow a group of gay, lesbian, and bisexual descendants of Irish immigrants to march behind a banner stating their cause. The Supreme Judicial Court of Massachusetts subsequently determined the council violated the state public accommodations law. The United States Supreme Court reversed, holding that because the parade was a form of protected speech under the First Amendment, the public accommodation law could not be used to compel the council to host the message. The court stated that whatever the council's reason for keeping the message out of the parade, it boils down to the choice of the speaker not to propound a particular point of view, and that choice is presumed to lie beyond the government's power to control. The court held that compelling the council to host the message violated a fundamental rule of protection under the First Amendment, that a speaker has autonomy to choose the contents of his own message. And the case further emphasized that where dissemination of a view contrary to one's own is forced upon a speaker intimately connected with communication advance, the speaker's right of autonomy over the message is compromised. The importance of protecting an individual's autonomy over his or her speech was most recently adjusted in a case called Janus. There, Janus, a non-union employee, objected to paying the agency fees for a union. The union claimed agency fees were based on collective bargaining agreement. However, Janus objected to paying the fees because he disagreed with the collective bargaining position. The Supreme Court concluded that requiring Janus to pay the agency fees violated his free speech rights because it compelled him to subsidize the union's speech. The court stated that compelling individuals to mouth support for views they find objectionable violates the cardinal constitutional command that individuals have autonomy over their speech. The court explained that free speech serves many ends, and whenever the federal government or state prevents individuals from saying what they think on important matters or compels them to voice ideas with which they disagree, it undermines these ends. The court further explained that where speech is compelled, additional damage is done because it forces free and independent individuals to endorse ideas they find objectionable, which is always demeaning, and coerces individuals in betraying their convictions. Generally, there is no free speech protection for non-expressive business activities. However, some businesses like tattoo studios and video game companies do create and sell products that are protected free speech. A business does not forfeit the protections of the First Amendment because it sells its speech for profit. As we stated in Coleman, the degree of First Amendment protection is not diminished merely because the protected expression is sold rather than given away. Likewise, the Supreme Court stated in Riley that a speaker's rights are not lost merely because compensation is received. A speaker is no less a speaker because he or she is paid to speak. However, simply because a business creates or sells speech does not mean that it's entitled to blanket exemption for all of its business activities. Like any other organization and activities, no business is likely to ever be exclusively engaged in expressive activities, and even the most expressive business will be engaged in non-expressive business activities. Thus, for example, in Pittsburgh Press Company versus Pittsburgh Commission, the Supreme Court held that while the First Amendment protected the content of articles published in the newspaper, it did not protect the newspaper's facilitation of illegal hiring practices by publishing gender-specific employment advertisements. Here, the First Amendment does not protect all of plaintiffs' business activities or products simply because they operate Brush and Nib as an art studio. However, plaintiffs' custom wedding invitations and the process of creating them are protected by the each custom invitation created contains hand-drawn words, imagery, and calligraphy, as well as hand-painted images and original artwork. Additionally, the creators are intimately connected with the words and artwork created in their invitations. For each invitation, they spend many hours designing and painting custom paintings, writing words and phrases, and drawing images and calligraphy. Moreover, they insist on retaining artistic control over ideas and messages contained in the invitations to ensure they're consistent with their religious beliefs. In short, here, like creating tattoos and process of tattooing in Coleman, the plaintiff's custom wedding invitations and the creation of those invitations constitutes pure speech entitled to First Amendment protection. The city argues, however, that the plaintiff's custom invitations do not implicate pure speech protection because they only convey logistical information such as time, date, and location about a wedding. Thus, like scheduling emails in a prior case, the city contends that plaintiff's custom invitations do not implicate speech in a constitutionally relevant way. We disagree. The city concedes that every custom invitation contains language that's celebratory of the wedding. Moreover, viewing the invitations as a whole, it's clear that the plaintiff's artwork, calligraphy, and hand lettering is designed to express a celebratory message about each wedding. Moreover, the plaintiff's inclusion of original artwork and celebratory words and phrases has an emotive impact on the overall message of the invitation. The city's comparison of this case to the prior case Fair is inapt. In Fair, an association of law schools and law facilities challenged the constitutionality of the Solomon Amendment. That law required the Department of Defense to deny federal funding to any institution of higher education, including law schools, that prohibited military recruiters from gaining access to campus. Because Congress had adopted Don't Ask, Don't Tell policy excluding gays and lesbians from serving in the military, Fair objected on free speech grounds to providing military access to their campuses for recruiting purposes. The court rejected Fair's free speech claim. Specifically, it concluded that Fair's actions in denying or granting access to campus involved conduct, not speech. Additionally, the court states that emails and notices Fair sent to students advising them about times, dates, and locations the military was on campus was plainly incidental to the Solomon's Amendment regulation of conduct. Simply because Fair included words either spoken or printed as a means of granting access did not transform Fair's conduct into a personal expression. At bottom, the court recognized that Fair could not identify any personal expression or speech intimately connected with permitting access to a room on a law school campus. The court concluded that schools are not speaking when they host interviews and recruiting receptions, and the law school's decision to allow recruiters on campus is not inherently expressive. This case bears no resemblance to that case, Fair. Here, plaintiffs' custom wedding invitations and creating of those invitations constitute pure speech. Plaintiffs used their original artworks, paintings, hand-drawn images, words, and calligraphy as a means of personal expression. In contrast, Fair was not intimately connected with empty interview rooms on campus, nor was it compelled to create emails containing words, phrases, and artworks celebrating the military's presence on campus. The city claims, however, that plaintiffs' refusal is not really based on speech, but rather discriminatory conduct directed at customers' sexual orientation. The dissent similarly, but incorrectly, asserts that plaintiffs seek to decline their products or services based merely on plaintiffs disfavoring or disapproving of certain customers. But these arguments mistake the plaintiff's position, and they're not supported by the record. Duka and Koski never testify nor argue that their faith prohibits them from serving a customer based on sexual orientation. Rather, they argued and have testified that they're willing to serve any customer regardless of status, and no contrary evidence has been presented. Additionally, the record contains no complaints against plaintiff for discrimination against the plaintiffs based on or against customers for sexual orientation. Nonetheless, the city argues that the plaintiff's discriminatory intent is shown by the fact that apart from one name, a custom invitation for a same-sex couple is identical to that for a homosexual couple. We reject this rather myopic view of the invitations, which defies the very nature of speech and art. Speech must be viewed as a whole, and even one word or brushstroke can change its entire meaning. For example, in Hurley, the Supreme Court determined that one banner in a parade of 20,000 participants changed the expressive conduct of the entire parade. Thus, for Duka and Koski, writing the names of two men or two women, even when the names could refer to either male or female, clearly does have and alter the overall expression of the content of the wedding invitations. Overall, the city's analysis is based on the flawed assumption that plaintiffs' custom wedding invitations are fungible products like a hamburger or a pair of shoes, and they are not. Plaintiffs do not sell identical invitations to everyone. Every custom invitation is different and unique. For each invitation, they create different celebratory messages, paintings, and drawings, and they also personally write in calligraphy or custom-based lettering the names of specific bride and groom who are getting married. In short, plaintiffs do not create wedding invitations for any couple, regardless of whether the wedding involves a man or a woman or a same-sex couple. Next, both the city and dissent contend that while the custom invitations themselves may contain protected speech, plaintiffs' refusal to create them for and sell them to a customer for same-sex wedding does not implicate speech. We disagree. The process of creating and selling pure speech, which undeniably involves decisions about what to create and what not to create, is protected by the First Amendment. The city also argues that because plaintiffs' refusal affects only same-sex couples, the refusal is essentially a proxy for discrimination based on sexual orientation. We disagree. The fact that plaintiff's message refused primarily impacts customers with certain sexual orientations does not deprive plaintiffs of First Amendment protection. For example, in Hurley, the council's decision to exclude the banner effectively excludes all other parade participants who may have wanted to express their pride in sexual orientation by marching behind similar banners. But because the impact was based on message, not status, it was protected. The city also claims that invitations are the customer speech, not the plaintiff's speech. According to the city, because plaintiffs include the information requested by the customer, they merely serve as a scribe or conduit for the customer's speech. This argument is not supported by the record. Duka and Koski are involved in every aspect of designing and creating invitations, and they retain substantial, if not complete, artistic control over the messages that are expressed in the invitations. But more importantly, the fact that the invitations may contain speech of both the plaintiff and their customers does not mean that the plaintiff's speech is unprotected. In Hurley, the court rejected the government's argument that the parade did not include the personal expression of the council because it incorporated speech originally created by others. The Supreme Court said that the First Amendment protection does not require a speaker to generate, as an original matter, each item featured in a communication. Likewise, in Coleman, we recognize that a tattoo reflects not only the work of the tattooist artist, but also the self-expression of the person displaying the tattoo in the relatively permanent image. Thus, we conclude that a tattoo is protected speech of both the customer and the artist, even where the artist uses a standard message or design to create the tattoo. The city and dissent make several other arguments, none of which is persuasive. For example, both the city and dissent claim that, to an objective observer, the custom invitations do not necessarily convey a message which they describe as endorsing same-sex marriage. This argument, however, erroneously applies the Spence-Johnson test for expressive conduct to pure speech. Whether a third party is able to discern any articulable message in pure speech, especially artwork, is simply irrelevant in terms of whether it's protected under the First Amendment. Nothing illustrates this principle more clearly than Coleman. There we held that tattoos are protected pure speech, even though as a practical matter, the message or meaning of many tattoos may well be indecipherable to an objective observer. But because tattoos contain personal expression of the artist, we held tattoos are protected pure speech. In a related argument, the city and dissent claim that if plaintiffs have any protected speech rights in the invitation, it is limited to statements endorsing or supporting same-sex marriage. This argument simply ignored plaintiffs' right to create messages that celebrate a same-sex wedding. Possibly, the dissent ignores the right because, as the city concludes and concedes, every custom wedding invitation plaintiff create contains the language that's celebratory of the wedding. And of course, there's no legal justification for holding that freedom of speech only protects messages that endorse or support same-sex weddings, but not supporting other weddings. Indeed, as the Supreme Court has stated, the right of freedom of speech includes any medium for communication of ideas that may affect public attitudes and behavior in a variety of ways, ranging from direct espousal of political or social doctrine to subtle shaping of what thought characterizes all artistic expression. The remaining arguments raised by dissent are equally unavailing. For example, the dissent claims that there's no compelled speech because nothing requires Brush Nib to identify itself as the supplier of the invitation or precludes it from disclaiming that its sales constitute endorsement or belief of customers. However, the essence of free speech protection is a person's autonomy over what they say and when they say it. We fail to see how plaintiffs' autonomy over their speech is protected by requiring them to conceal their identities as artists and disclaim any responsibility for creating artwork that contradicts with their messages. The city's concern that our decision will undermine the anti-discrimination purpose of the ordinance or that it will encourage other businesses to use free speech as a pretext to discriminate against protected groups is unwarranted. Our holding today is limited to plaintiffs' creation of one product, custom wedding invitations that are materially similar to the invitations contained in the record. These invitations, unlike most commercial products sold by public accommodation, are unique because they consist of pure speech. Nothing in our holding today allows a business to deny access to goods or services to customers based on sexual orientation or other protected status. Additionally, the dissent claims that our holding conflicts with such cases as Heart of Atlanta Motel and Newman versus Piggy Park. Those cases did not involve compelled speech, but rather business owners who refused to serve African Americans solely based on race, a practice plaintiff explicitly condemns, and our holding nearly permits nor condones. Freedom of speech and religion requires tolerance of different points of views. In a diverse pluralistic society such as ours, tolerance of another belief and point of view is indispensable to the survival and growth of our democracy. For this reason, we've always recoiled at those governments and societies that repress or compel ideas or religious beliefs. It is the duty of the judiciary to enforce the text of our Constitution and statutes and fundamental rights protected within them. Enforcing and protecting these rights preserves individual freedom of mind in preference to officially disciplined uniformity for which history indicates a disappointing and disastrous end. And while our dissenting colleagues may view a result contrary to our holding today as more progressive, it is not forward-thinking to force individuals to be an instrument for fostering public adherence to an ideological point of view they find unacceptable. After all, while the law is free to promote all sorts of conduct in place of harmful behavior, it's not free to interfere with speech for no better reason than promoting an improved message or discouraging a disfavored one, however enlightened either purpose may strike the government. To conclude, we hold the ordinance as applied to plaintiffs' custom wedding invitations and creation of those invitations unconstitutionally compelled speech in violation of the Arizona Constitution's free speech clause. We further conclude the ordinance as applied to plaintiffs' creation of custom wedding invitations substantially burdens plaintiffs' exercise of religion, and the city has not demonstrated that its application of the ordinance to plaintiffs in this way is the least restrictive means of achieving its assertive interest in eradicating discrimination. Thus, the application of the ordinance in this case violates plaintiffs' free exercise rights under the statutes. Finally, because plaintiffs intend to refuse to make custom wedding invitations celebrating a same-sex wedding is legal under the free speech clause of Arizona's Constitution, plaintiffs are entitled to post a statement consistent with a holding indicating their choice. This case, I'm sure, will be cited by other courts in other jurisdictions as they're wrestling with this issue in other jurisdictions, but I think this is the end of this case as far as this goes under this fact pattern. So, the custom creation of wedding invitations is, to me, right. And I also like what the Supreme Court said, that this line that they're trying to establish pertains to speech versus not speech, activity versus speech. So when they're looking at these things, other businesses that are not engaged in speech don't have a claim under this kind of statute. What they're doing here is very literally creating speech. They're looking at creating words that are written on a page, and they're looking at creating an art. Now, I think we can all agree that art is protected by the First Amendment and freedom of speech. I think we can all agree that words on a page are protected by the First Amendment and freedom of speech. So the only question then is, whose speech is it? Is it just the person who's commissioning it speech, or is it also the artist's speech? And so once you say, well, we look at this and we say, look, these aren't just merely transcribing words on a page. This isn't merely just typing this up. This is someone who's using artistic license to create things, to make drawings, to make letters in just a particular kind of configuration. This is art. And so even though it might be commissioned by the client and therefore it reflects the client's speech, and I don't think even the Supreme Court denies that this is the client's speech, that fact does not preclude it from also being the business's speech, because the business is transforming the client's request, transforming their chosen words into the particular expression of the artist. It's not merely typefacing on an envelope. That might be just pure recitation of the client's request. Here, this is using artistic creation to make artistic drawings, artistic words, artistic speech, artistic lettering, and therefore involves clearly the speech of the client, but also clearly the speech of the artist as well. They're both implicated, and so they both have a free speech interest in this. So in the same way, if the government was saying to the business, you can't create this kind of speech, it would implicate both the client and the artist. In the same way, when they're saying you must create this speech, it implicates the right of both the client and the artist. So for me, this is a correct decision because it is based on the speech interest in the artistic words and the written words. So unless you want to argue that making drawings and making calligraphy doesn't count as speech, or unless you want to argue it doesn't qualify as the speech of the artist, then I think this decision must follow. And I don't think that it therefore follows that other businesses will be able to color what they're doing through speech, because most other businesses are not creating speech. They're not doing things that are recognized as speech in this way. I think, as long as we say that creating paintings is art and that's speech, as long as we say creating words on a page is speech and that's art and that's free speech, then I think this conclusion must follow, because it is clearly, in my view, the speech of the artist and as well as the client. But I did see there were some people here that were dissenting with that. So let's read some comments that were happening. So we'll read some of that stuff that you guys were saying and see what you guys had to say on it. Captain Terrific says, doesn't this all presume that the card maker is making a message by printing the card? Yes, it does presume. It presumes that the card maker, by making this, is engaging in speech. So if it is just the client's speech and nothing more, this argument doesn't fly. It has to be that the person who is making the card is engaging in speech as well. And it can be a co-collaborative speech. They both can have freedom of speech rights, right? The idea that two people are involved doesn't necessarily imply that it's only the free speech of one versus the other. So this all is dependent on the idea that it is the person creating the speech when they type it. So if it's merely typeset, I think this argument would be a little bit harder, because merely typesetting isn't really creation of new speech. But here, with the artistic creation of art and the artistic creation of calligraphy, I think that does implicate the free speech issues of the creator as well. So that seems like what is going. Yeah, Captain Terrific says anyone who prints anything speaking, again, depends on, I think it would depend at least in part based on creativity. You might be able to say that even pure typesetting is enough, but I think this is more than that. And so, regardless of whether pure typesetting is enough to trigger this same analysis, we're beyond that. So, I think, we have to look at the more extreme case before we look at the narrower case. And so I think, the court isn't necessarily saying that typesetting would or would not be implicated. It's simply saying that here, this is a lot more than that. And so there's a free speech interest there too. Captain Terrific again says, when can we determine a line for pretext for discrimination? To me, and also to the court, I'm not sure it matters whether there's a pretext or not. If it's creation of speech, then pretext is irrelevant, because there's a right to not create speech even if it's based on pretext. You can't force someone to speak even if it's based on a pretextual reason, because compulsion of speech is not protected. And that's what the court here is saying, and I think that's probably right. I don't think you can always say, again, Captain Terrific, I don't think you can always say it's speech and against my religion. Those arguments don't always work. A freedom of religion analysis has a whole different case law. People have done the freedom of religion analysis before, and it doesn't work in a commercial business, not for the least of reasons, that most commercial enterprises are not religious in nature. And the Hobby Lobby case is an exception to that. But in terms of that dynamic in closely held companies. But most business enterprises are not religious in nature, so they can't make a religious argument because they don't really have a religious interest as far as a company goes. So, whether this would work in a closely held business in a freedom of religion context, I don't know. But we're here on a freedom of speech argument, and speech is, of course, a different right protected by the Constitution, both in Arizona and in Arizona and in the First Amendment as well. First Amendment contains 5 different provisions. For freedom of speech is one, and freedom of religion is another, and they have their own separate analysis as well. So there's a different argument there. So that's how I feel about it. I think this conclusion is right. I think you has to be right because otherwise, we have a real problem when you have businesses that are promoting speech. Can if you say that this is right, then you can force a tattoo artist to do tattooing. You can force people who are engaged in speech, pure speech, to engage in speech on a commercial business. That can't possibly be correct in my view. So I think this has to be correct.